Today's episode of In Our Expert Opinion podcast features Andrew Diaz. Andrew is a partner at Gaylord Merlin Ludovici Diaz out of Tampa. He is an eminent domain attorney, and his firm 100% specializes in eminent domain work. So I hope this is a fun episode, very informative, very educational. And again, for me, at least, and others, I know it's a subject we don't know a ton about. And so this is going to be a lot of fun. We had a great conversation. Andrew is a great friend of our firm. They've sponsored a lot of our land conferences. He's spoken at a lot of our events. He's a lot of fun, big personality. We're going to have a good time. I do want to remind everybody listening and watching that this is not legal or tax advice. Andrew is an attorney, but if you have a situation involving eminent domain on your property, please hire your own attorney, consult professional legal advice. Thanks, and I hope you enjoy.
In Our Expert Opinion podcast is brought to you by Saunders Real Estate, a full-service land and commercial brokerage helping clients make bold and informed investment decisions since 1996.
Good afternoon, and welcome to another episode of In Our Expert Opinion. Today, I'm joined by a true expert on his subject, which is eminent domain. I'm joined by Andrew Diaz of Gaylord Merlin Ludovici Diaz. Andrew, welcome.
Oh, thank you. I appreciate you having me.
I should say welcome again. This is your second
yes.
time joining us, at least the second time.
Yes.
Today, we're going to be talking a lot about eminent domain, what it is, what it's not. Really, I think we're going to use a lot of case study examples, real world examples of properties that Andrew has had the pleasure of working on over the years to really educate our audience. If you're anything like me, which most of our audience is, I think I've always historically viewed eminent domain as, okay, the government's coming to take my property or take a piece of it, and they just have to pay me what it's worth. And that calculation is a lot simpler than the work that you do that we're going to learn about, which is making
the owner whole. That's the whole concept here in Florida. Where Florida is different than any other state in the country is our standard of compensation for the property owner is full compensation. It's not fair market value. It's not just compensation. It's full compensation. And full compensation is set forth in the Florida Constitution, and it requires that the condemning authority, the government agency, whether it's a city, state, county, sometimes a power company, Florida Power, Duke Energy, they all have the power of eminent domain. The railroads do. And if they are proceeding by state law, they have to pay the property owner full compensation. And that includes paying for the land taken, paying for damages or the impacts in value to the remaining property. They also have to pay for what's called the cost to cure. There's sometimes mitigation that has to be done on site. You may have to redo your parking lot. You may have to do other things. They have to pay for that. And importantly, they have to pay for the attorney's fees and costs that are incurred by the property owner. And the reason Florida is different is that it requires the payment of attorney's fees and costs is that the drafters of the Florida Constitution realize that a property owner has done nothing wrong, yet finds themselves in the crosshairs of a government taking
where they need legal representation.
Where they need it's a legal proceeding, and they're taking something, and the property owner finds themselves in the crosshairs of a state agency, and through no choice or through no fault of their own, they've done nothing wrong. They're not accused of a crime or a breach of contract, that they need legal representation. If it's truly a public purpose that the taking is for, then the public should have to pay the attorney's fees and costs, and it shouldn't fall on the shoulders of that property owner that they have to come out of pocket.
Penalize the property owner for nothing that they've done
That's
wrong.
exactly right. And so Florida is different. So our whole focus as eminent domain lawyers, and that's all our law firm does, is we represent property owners throughout the state of Florida, is to represent the property owners, make sure that procedurally everything is done correctly, and make sure that we're able to present a claim for full compensation, and make sure at the end of the day, to the extent that Florida law allows, that they are made whole and are treated fair.
Yep. How often do you see people go through eminent domain without having representation? Is that something that happens, or is this an education of the audience kind of thing where people just don't know all of what we're going to talk about and don't know that their legal fees are covered?
Yeah, well, that's a great question. There is a percentage. I don't know how much. There are quite a few people that try to go at it on their own. I think that there's, for forever, people have a healthy distrust of attorneys. I get it.
Not you. No.
I get it. And I can tell you, fortunately in the state of Florida, the way the attorney's fees and costs are paid for, it's based on a percentage that the lawyer can achieve over and above the first written offer. And so it's paid, it doesn't come, the attorney's fees does not come out of what the property owner is paid. It's over and above based upon the increase that lawyer is able to achieve. So it's different than a personal injury type case that most people have
Those are
knowledge.
netted out.
Those are netted out.
Yeah.
And so one thing, it doesn't come out of your award. It doesn't penalize you to have an attorney. But what I think happens is that, people, especially, if you're in the real estate industry, you have a very good sense and experience of what something is worth. And a lot of the takings, it's a situation, what is the area taken?
Yep.
You can figure out a value.
The property's worth $100,000 an acre, and they take
Yes.
half an acre, it's worth $50,000.
Yes. But the thing about
That's a simple theory.
simple, and I think most people go into it thinking, well, that's fair. I can do it. I don't have to get myself involved with a lawyer. But I recently had somebody call me that has negotiated with the DOT for a while and asked me if it's a good deal. And my response is, I have no idea if it's a good deal. The reason I answered it that way is if it's a partial taking, in that situation it was, where when I say partial taking, they're
Not the
taking
whole property,
they're taking part of the property and there's a remainder. Well, I don't know what the level of the road is. I don't know what the drainage is going to be. I'm not sure what the access is going to be. In order to know if it's a good deal, you need to know what exactly is being built in the part taken. And so there are so many details, and in every case, my background, I got into the field of eminent domain because before I went to law school, I was a state certified real estate appraiser. So I feel very confident in the valuation and the theories and the concepts, but still always try to get an appraiser involved. But engineering, I'm not going to pretend. I know water typically flows downhill, but when you're talking about access points, the grade of the road, how much higher they're building, things of that nature, it is critically important to get somebody involved that can forensically look at a set of construction plans, and the condemning authority has to provide that. And if they don't, you can assume worst case scenario. So, to understand or to know whether something is a good deal or not, you need to have that forensic analysis, especially engineering. And so I think most people don't know and all of that is, all those costs are covered by Florida law. That's part of full compensation. So if I have an appraiser, an engineer, or a land planner, those costs are taxed against the government.
So there's no harm in bringing in the right team members.
No. In fact, I think it's a huge mistake not doing that, because you literally are leaving money on the table, and you are also probably going to face a problem that you didn't realize that you had.
Or that you just didn't understand. You're putting more on your shoulders to carry that burden to figure it out.
That's exactly right.
And so when we talk about full compensation, we're going to get into some of these examples, but can you talk a little bit just theoretically about how that theory comes about, right? Again, I'm thinking about this purely from a dollars per acre, perspective, the simple view. But when we talk about full compensation, there's several examples we'll get into of things that even I would not have thought about, or most people wouldn't think about, whether it's property equipment, whether it's the historical side of a building, or the impact of zoning on what you could do before the taking versus after the taking on a property because of the size or the setbacks. Can you just kind of talk about some of those other things that, again, outside of access points, the road where it's going, the elevation, some of the paper invisible type of things that people just don't think about being impacted by a taking
that's a great question. What comes to mind, it's going to be in one of our examples, is like, for example, we had a property owner a few years ago that had a great piece of property, great development potential, that its access was through a reciprocal agreement that it had with its neighbor. And when the Department of Transportation came in to acquire it, the DOT did not know about that and valued the property as well. It has limited road frontage and accessibility is negligible, therefore valued at real low. And so when we came in and asked our client about the access point, I've got this agreement with my neighbors. Is it in writing? No. But they've had that relationship for 30 years.
They've had a handshake agreement. For
Exactly. And so fortunately these are two neighbors that have worked together for the last 50 years. We had to get a documented license agreement, or I'm sorry, not a license, an easement agreement, which basically papered and memorialized that agreement. And without that, the property had negligible value. Now, in the real world, they worked together. They that value was there, that understanding was there. But when they came to take it, if that paper wasn't there,
It's not on the title report.
that's exactly right. My client would not have been able to get the compensation that they should have. A lot of times, too, a taking might get a property where it no longer meets the minimum size standard. It might require variances. And so these are things that we all have to check into as part of the investigation as to what makes highest and best use, which leads to full compensation.
Do you ever see situations where that debate about remaining use is not black and white? Like, let's just say I own 1 acre at a hard corner, and for whatever reason, FDOT or whatever government authority needs to come in and take 30 to 40% of that 1 acre site. And is that an argument where I could make as a landowner of, hey, before that taking, I could get a high-end gas station or fast food user. Now, because the site's so much smaller and retention requirements and access things like that no longer, I can't get that high-end user because the site's not big enough, it's not functional enough. Even if it meets the zoning code, it doesn't functionally work the way it should. Is that a situation that you see a lot?
We have that fight literally every day of my practice. Absolutely. And what's interesting is when we were talking about that, that happens all the time. I mean, with let's say you've got a piece of property that it was developed prior to some of the on-site retention requirements. Then the after situation, if you start doing some certain improvements, it kicks everything new.
Yeah, nothing's grandfathered.
Nothing's grandfathered. And then what ends up happening too, another thing that comes to mind is there's a taking and there's a loss of parking, but you still meet the zoning code. A lot of times condemning authorities say, it's not a problem, you still meet the zoning code. Well, the zoning code is not, a lot of...
I can't get the parking.
Well, a lot of retailers want 5 spaces per 1,000 square feet.
That's right.
Or even more, higher.
Yep.
And so it's like, well, you meet the parking code, no damages. Well, you don't meet our industry or our, we all know.
My functional use of the property is not what it is anymore.
And that's what I think that we do quite a bit of. An eminent domain attorney who's representing a property owner needs to understand how that particular owner uses their property, because we keep going with functional utility, how that property functions for that particular owner. And what's important, this goes back to your first question about full compensation. The compensation is not to the market. What we have to look at is the loss to that particular owner. And that it's the owner's loss, not the condemnor, the government's gain. And so every day we keep asking ourselves, how do we make this owner whole? How is it used by this property owner? And to what extent can we return that functional utility? And a lot of times you can't, and that's where you get the damages over and above that.
Your background as an appraiser, how helpful has that been in this business? As you just talked, I just thought about this, man, I bet you have a leg up on a lot of other domain attorneys because you do understand a lot of the real estate components.
I'm fortunate that I couldn't have scripted it better. Not that I started it down that path, but it worked out well. And I was fortunate enough when I was an appraiser to be exposed to eminent domain. And I went to law school, hoping to get into the eminent domain practice. And I was fortunate enough that when I was in law school, I went to Stetson, and the Pinellas County attorney, her husband happened to be a real estate appraiser, and felt that it would be great to have somebody working with the lawyers that had an appraisal background. And so I worked there as a law student for 2 years. The right person quit right before I graduated from law school. I practiced there for 2 years and got to meet people, whether it's opposing counsel, a lot of the experts that I still work with. I got to, watch them practice their trade, got to know them, and I practice with them. They've become dear friends, and it's kind of, we were talking, I've got a birthday coming up and I have to laugh that,
Tomorrow.
yes, it's tomorrow. But I have to laugh because these are people that I've known for 30 years, working against and together. But it's been, my real estate appraisal background is so much fun. I mean, this week, I've got a substantial case in Citrus County for the extension of the Suncoast through the Crystal River area. And literally this weekend, I was doing research. I was calling, verifying sales, finding the buyer, the seller. Something didn't look right, was able to contact.
You're wearing your appraiser hat.
And I loved it. Yeah. Looking at deeds, calling people that were involved in the transaction.
If the eminent domain thing doesn't ever work for you, we could find a place as a research analyst here at Saunders for you if you ever needed it.
Well, by the way, Zane was very helpful for me.
Good. Well, there we go.
So thank you to your team. Yes.
I love that. So for the audience, the previous podcast we did with Andrew was very much a deep dive into eminent domain law, what it is, kind of the nuts and bolts. This is going to be a little bit different. I wanted this to be real, very real life conversation of real impacts to property owners, hypotheticals, but actual some real examples. So we'll kind of make a transition here into some case studies and properties that Andrew's worked on over the years. And really, I actually heard you give this kind of presentation several years ago at one of our conferences, and it was so interesting, so much fun to kind of learn about eminent domain in a real life context that I thought this would be perfect for today. So the first property I want to bring up, and you can kind of set the stage a little bit, is a coffee roasting plant. And so this property from an eminent domain perspective was probably different than a lot of the ones that you've typically worked on or ones that we've talked about. Right. Where it wasn't just the dirt or the property or the building, but it was, again, it was special use. There were some equipment pieces to the puzzle here. If FDOT or the government agency took this property, again, making that owner whole. Right. How did that play out?
Well, this was literally one of the most challenging cases that I had, and it was basically a nondescript, 33,000 square foot warehouse. Was probably built 60, 70 years ago, just outside of Ybor City. If you're familiar with the crosstown in the Tampa area, it's right there near the IKEA. Store. And
not too far from Columbia.
Exactly. Literally, it is, a few blocks south of Columbia. Exactly. And this was a guy.
I relate everything back to food. So if we're talking coffee, we're talking Ybor, we're talking the Columbia.
There you go. So yes, and so our client was a gentleman who literally grew up in Ybor City, and he was, started as a coffee salesman and ended up staying in the coffee business. And at this, his business was really impressive at the time of the taking. He was probably the largest independent coffee roasting facility in the Southeast United States. I mean, just total success story. And so the challenge here was, you've got this family business that, he's got his warehouse, and he has got it set up with, in their industry, they call them their production trains, where basically the raw bean goes in.
They come in, they go on the train.
They go on the trains, from their roasters to their grinders to their packaging, everything.
I can just smell all this.
Oh, it's incredible. You smell, when they're roasting, because you definitely can smell it. And so the equipment that he had in there, I mean, it was fascinating. Raw bean goes in, goes through the process. Next thing you know, it's packaged and goes out on a truck. And so the equipment that he had in there was equipment that he had put together, specially designed, specially laid out over a 60-year process. Now, or time frame. It was not new, but from a function standpoint, and that's what you talked about. Yeah. From a function standpoint, it worked as good as anything. It's kind of like it was the Rolls Royce of
older equipment, but that was geared specifically towards their intended use and purpose. There was some customization.
It was all customization. You could not go in there and you could not replace what he had. So the way the Department of Transportation took a look at the factory was it's a warehouse, and all of that equipment could be easily moved or relocated.
Yeah.
Well, not so fast. This was the way, and going back to appraisal, the way we looked at this is a special purpose property. It was not, you can't find it in the market. You have got to create it.
Especially in Ybor.
Exactly.
As well.
Exactly. You could not replace that from the size and the footprint. Couldn't do it. So what we did, so the question was the challenge to make this manhole, what amount of money would allow him to go out and replace what he have and what his needs be. So, out of Central Casting, we found a coffee expert out of Seattle that put together factories for Starbucks. He came in, analyzed the entire operation, and gave us a cost estimate of what it would be to equip a factory like this. So
Go pick this up and move it somewhere else.
Well, not even pick it up because you couldn't.
Correct. Well, go find another facility that could accommodate his needs.
And so you couldn't. So we did a cost approach, which under appraisal theory, a special purpose property, a cost approach, you'd have to apply
because there's no comps.
There's no comps.
Yeah.
There is no comps, and that's
there's
what
not
we're
an
able to
income
show.
approach to this property either.
No,
Just,
no, and the tough part for him too, under Florida law, and we don't like this, but it's the way the law is. If it's a total taking, you are not entitled to business damages. So, we had to, that was a challenge. I mean, if they took part of the property, we could look at some of the income generated from the business, but that we were not able to do
the entire property. You can't look at the impact to the business profits or loss.
That's exactly right. You've got
into question only if it's a partial taking.
That's exactly right.
Interesting.
Yes, and
so that's really impactful from a context of somebody who has a business operation in this location too. Again, I think about eminent domain and for us a lot in the land business from a land perspective.
Right.
But if you're talking commercial property, commercial buildings, operating businesses, that's a huge thing you have to navigate, I'm sure.
Yes. And so, what we did was we did a cost approach. We valued the real estate, what it would take to replace this real estate, and then replace the equipment, because there's a theory where valuing a factory, it's all put together. So that equipment becomes part of the real estate. It is put in with the intent to stay there forever. It's customized. It operates. Who knows if you could put this stuff back together.
Right.
So fortunately, we had a huge discrepancy in the value. Thank goodness for our client that the DOT had 2 warehouses that they acquired several years ago on a project. And went through the proper procedure that those were available. So we were able to get title to those 2 warehouses, which were each about 30,000 square feet. And we were also able to get him a substantial amount of money over and above that, which he would need to set forth the equipment. And we were able to negotiate whatever equipment he could get out of his factory.
Gotcha. So some of the stuff he might be
able to salvage, but you wouldn't know that. And so, I'm proud to say it. The company is Brisk Coffee Company. It's still there in Ybor City. They're doing great. It's being run now by Denise Reddick, who is the owner's daughter, and they're doing fantastic. But that was a situation where we were looking at this property so much differently than the DOT. I think at the end of the day, we were looking at about the total package that they got, cash equivalent, probably over $7 million.
Wow.
And the offer was less than $1 million, because DOT was looking at it as it's a warehouse and we can move the equipment. And that did not solve the problem. And it was hotly litigated by both sides, and we were able to resolve it before. It's interesting. We talk about eminent domain. Eminent domain, if you can't get to a resolution, there's a jury trial, and you get 12 jurors. And there's only 2 times in Florida where you get 12 jurors, and that's a situation where the defendant is on trial and the death penalty is in play, and eminent domain. So when there's a saying, when the government's trying to take your property or your life, you get 12 jurors. But this was a case that was hotly litigated, and we did settle before trial, but it went pretty far down the process, and so it was a fun one.
I bet, and impactful.
Different. Oh, absolutely.
And it's wonderful. I'm sure you get a lot of excitement and thrill and joy out of watching businesses like this that you were able to help navigate an extremely complicated, difficult situation, continue to thrive.
Yeah, and I'm saying it. Every time I drive through Ybor City in the crosstown and smell their coffee, it reminds me of the battle that we had, and just thankful that it worked out well, and it worked out the way it should have.
Yeah, sounds like you drink plenty of coffee getting that one done.
Yeah. Absolutely.
Want to talk next about kind of probably the traditional thought, not traditional, but again, when I think eminent domain, I think mostly land, and probably in Florida, maybe I'm wrong, but it seems like given the state's growth and new road systems that are coming in and have come in, that there's a ton of impacts to landowners from an eminent domain perspective. And so this looks like a pretty sizable mixed use project near 52, Pasco County, I'm assuming. And so
Yes.
just kind of want you to kind of set the stage a little bit on this one, kind of talk a little bit about the property owner, what their use was going to be, how the road that kind of curved through the middle and connected, how that impacted, again, their intended uses, some of the topography challenges with this site and things like that as well.
Well, this second case, it's a residential mixed-use development, was the highest and best use of the property. It's about 200-plus acre site, strategically located at State Road 52 in Prospect in Pasco County. And that, I mean, there's so much growth going on here. And so our client...
That's just about the corner of Main and Main.
Absolutely.
In Pasco. Yeah.
Absolutely. And so, our client was going through the development process, but the local government wanted a dedication of this roadway. And, there's some questions as to, if you want your permit, do you dedicate?
Yeah.
And so,
hold your feet to the fire.
Hold your feet to the fire. And so, the local government needed the property sooner rather than later, so they filed the eminent domain suit prior to forcing a dedication. And the position the county took in this case was that the property is ag.
Can I ask a question just to clarify real quick for me, and hopefully this will be helpful to the audience? Eminent domain versus a dedication.
Okay.
Just kind of theory-wise on this. A municipality can want you to dedicate right-of-way to them to build a road. That is different than the county coming in and taking your property.
Absolutely.
Correct?
Absolutely.
And so if you're a landowner who is feeling the pressure to do a dedication, is it better to wait and kind of hold out for the county to come in or city to come in and do a eminent domain suit to get that property or get that area, or is it a facts and circumstances?
It's all facts and circumstances, because what ends up happening is the eminent domain process is very slow. And so most developers, time is money.
Time kills all deals.
And so what ends up happening is that, you could be sitting there waiting literally years for a project to come through. What a lot of local governments do is you've got some that try to take advantage of that, others that don't, where it's basically, if you want a permit, dedicate X amount of feet. Under the Constitution, the legal standard is if they're going to, and I'll use the term exact, if they're going to exact or require you to dedicate any of your property, there needs to be a nexus or a connection between what your development is causing, the pressure it's causing to the road system. And
there needs to be a needed reason for it.
Yeah, but needed that your development is requiring the need.
Not pre-existing.
Exactly.
But
and so the situation with this particular property on State Road 52, it's that the proposed development of our client's property was not causing the need to widen State Road 52 or to do this extension. And so there's so much litigation on that, and it falls more in the inverse condemnation or regulatory type situation. But it becomes very, very complicated. And so it's one is a local government's trying to acquire by use of the police power, which doesn't require them to pay for it.
Right.
And so when they exercise the power of eminent domain, then all the property protections and rights to full compensation come into play and are there to protect the property.
I just thought that'd be good for the audience to hear the difference in those two terms, so they know, okay, here in this example that the county is wanting the dedication,
right?
But they needed that land faster, so they decided to ramp it up and not wait, and let's get eminent domain proceedings going on it, and you guys come into play.
Correct. Yes. And then part of the theory was, well, but for the project, you wouldn't have gotten the rezoning, so it's going to be ag. And then even if you get the rezoning, we've benefited your property because we've put a spine road through there that you can do all your development. And when you look at an aerial, kind of like, hey, you're putting a road right
down the middle.
We could have some access points, but that really didn't help. Especially you look at the road from an aerial, it doesn't look like a problem, but when you stand next to it, it's an elevated roadway.
Yep. Here's a picture, Eli, if you want to show that up to the people who are watching this visibly, the elevated roadway. I mean, that is a solid
you can't connect
10
to
feet
it.
or something. I mean, it's crazy.
Try 20 feet.
Yeah. I mean, it's hard to judge on the picture, but it's massive.
Yeah. You cannot cross that. And so, it's designed for, 55, 60 miles an hour. It's a limited access facility. You're not able to connect to that. And so, that is not like any type of spine road somebody would have in a development. And you couldn't get access to, at one point there was thoughts of the intersections with the major roads to have your commercial, high-end commercial.
You're creating corners.
Creating corners. Well, if you're creating a corner, there's a basic presumption you're going to be able to get access to that corner.
Correct. How are you going to get to those pieces if it's 20 feet in the air?
Yeah, and it's just cost prohibitive to connect. So, unless you really go in deep and see what the plans are, see what the roadway profile is, you're not able to really determine what the damages are. And again, this was a case that was hotly contested and litigated, and we ended up, at the end of the day, I think our client was taken care of.
Yeah.
But there's a lot that goes into it. It's not, what I go back to it is, and most people, when they get the offer packages from the government, they don't have the benefit of seeing the 3D concept.
Correct. So the government basically gives them an offer letter or a letter that, hey, we are going to start the eminent domain process on this property, and then an offer letter comes out. But before that, they might not, the landowner, property owner might not, it's not like the government's going to hand over all the details.
Well, what you can get, you can get the, they're required to give you the appraisal if you ask for it, the construction plans, maps and plans. But unless you have somebody that can read construction plans, it really means nothing. It's not much. It's very confusing. The appraisals are this thick. And a lot of the appraisers, not to negatively talk about your previous career, but they're looking at aerials. They don't necessarily have all the ins and outs of some of this. I think what's interesting too about the appraisal, the concept of valuation, the thing that we talk about as well is, there are certain things that are compensable, certain things that are not compensable. And what makes something non-compensable sometimes is the word that you use. So it's critically important to have somebody on your side who knows the vernacular of eminent domain.
Right.
And so what ends up, and there are certain things that the way the facts are presented would not be compensable. And so if your lawyers tell the appraiser that we don't believe this is compensable, they're not going to find that. Now, if we look at it and we tell our experts it's compensable, you're going to have a huge divergence in what the compensation should be. I remember having a case in Manatee County where it was a nice elderly couple that had a home, and they were concerned that they had to, the way where the median was being placed, be very close to their front door, and they would have to go about a half mile down the road before they can make a U-turn to head out. They had full access, right in, right out, left in, left out before. And so I was talking to the right-of-way agent, and she told me, and I think the world of her, by the way, she goes, well, access is not compensable for residential. And I'm like, let me get this right. You're building the median in property you're taking from them, and you're saying that it's not. I go, where's that written? I've never seen that statute or that case, because there's not one. And so we were able to get our client several $100,000s more because of that. But if you just go by the information the DOT is giving you, it may be the way they're interpreting some of the case law and applying that to is really not right. Or there's another side to argue on that. And so, there sometimes we go through it, and the offers make sense, but we still want to
double check and go through all the details.
Absolutely.
Look for things that were missed.
Yes.
So I think, the next one I want to talk about is really fascinating. And for me, I found this one really neat when you gave your presentation, but the Tampa Theater, right? Iconic building in downtown Tampa, been around for forever.
Yeah.
And I'm sure this was a really fun one for you as well, and close to home and close to your heart. So kind of set the stage for this one.
This one was probably one of the most interesting, and I'd say, for lack of a better, funnest cases that I've ever handled. And what was great is, I remember I'm born and raised in Tampa, and I remember being a little kid going on field trips here. I think I even saw the movie 10 Commandments with Charlton Heston there. And I mean, so it's just it's a beautiful, beautiful theater and a beautiful, beautiful setting. It's really fortunate to have it in downtown Tampa. But what's happening here is my clients were the heirs of their grandparents leased the land to the movie companies that built these palace type theaters. And so it was, they're probably, a few examples all over the country, but so, we were presented with this, you got a 100-year lease.
Ground lease.
Ground
Your
lease.
your client owns the dirt underneath the theater.
A little more complicated than that. Our clients owned 11,000, one half interest in 11,000 square feet, which is just part of the complex.
Gotcha.
One half interest.
One half interest of 11,000 square feet, which is a quarter of an acre roughly for people here.
Yeah, basically it was where the actual stage and auditorium are for the Tampa Theater. That was
the most important part.
Absolutely. Sat on top of the property. And so the ground lease was terminating in 2023, and we got the case resolved before that. And so the city of Tampa, in one way, shape, or form, owned all the other pieces except my clients.
They own the other pieces of the dirt that were around
dirt,
it, besides
improvements, everything
the vertical
else.
improvements.
Yes, everything else. So, what was tricky about this is if the lease expired, all those improvements become my client's property.
Correct.
And so that seems pretty cool.
But to basically inherit the Tampa Theater and all the vertical stuff on top of it.
Yeah, but the question is, okay, what do you do with it? Yeah, because you really couldn't get to it because you didn't have rights in the lobby.
Right.
You didn't have, if you wanted to change a light bulb in there.
It's not like there's an access easement down the aisleway or something, right?
No, it's not. So it was basically it's like, well, do you really be careful what you wish for? It's a beautiful facility. It's really impressive. But, just to maintain that costs a fortune.
Correct.
So, the question becomes, okay, you get it. What's it worth? And so what ended up happening, and my clients, God bless them, they just wanted to do what was right and make sure that they were protected and taken care of. And that was great. So the city of Tampa did file an eminent domain lawsuit seeking to acquire the property for the public purpose of historical preservation. Okay. And so the question becomes, what's full compensation for my clients?
It should be, in theory, what is the value of 1,100 square feet of land in downtown Tampa?
That was my position.
Or half of the 50% of the value.
That was my position. So what the city in their appraisal, they went all over the country finding these, palace type theaters that were built in the 20s. And what they found in the research that most of them were all public use, because something like this really, because the cost of keeping them up, unfortunately, the majority of them have been torn down.
And the ones that do exist are owned by nonprofits, right?
Exactly.
Or cities or counties, right?
Exactly, because it's just really not feasible to operate something like this. And so, the valuation was pretty low because at the end of the day, it was thought of that, basically the improvements were a burden to the land, and the value of this property in the market was not worth much. So we started looking at it, and my analysis is exactly what you said. 100 years ago, my clients' grandparents came to the table with 11,000 square feet of property in downtown Tampa. They came to the table with that. To make them whole, they need to be able to replace that. And so what I did was we started doing some research. Now there's a concept in eminent domain law that a local government or government agency cannot benefit by their land use ordinances. And for lack of a term, you can't downzone a property, then try to acquire it, and then make the argument, well, it's not worth much because of your zoning. And so historically, we went back. This property was scheduled to be torn down in the 1970s. The city of Tampa stepped in, and I'm thankful that they did, and so are my clients, and got it on these historical registries.
Yep.
Preserved through historical preservation.
It's got to stay. You can't do anything with it.
And so we went back and did the timeline going back 20 years. And so, the exact purpose that for the same purpose that they put this property on historical preservation was the same public purpose to acquire it. And so our position was the city of Tampa cannot benefit today by taking it by paying a lower value for the acquisition, because the lower value was a function of
what they did back in the 70s,
preservations.
Right? Yes.
And so,
and if they wouldn't have preserved that and would have leveled everything there, your clients would have half an interest in
that's exactly
1,100
right.
square feet in downtown.
And so that's exactly right. And our argument was that the highest and best use of this property, absent that historical preservation, would be to sell to a residential developer. It's going on in downtown Tampa. You know, you see
high-rise mixed use
yes
apartments.
And so what was interesting is literally right across the street from the theater, just on the other side of Florida Avenue, there was an old building being torn down for a residential piece of property. And so at the end of the day, the city, we came to an agreement, and argument, but for this taking or this public purpose, the property, our clients could have gone out in the market, sold for whatever the value was, 200, 250, 300 square foot, and gotten that in the market. And so that's how we resolved the case. I mean, we were able to find some comparables, and literally it was funny because as we're in mediation, we're sitting in one of the office towers in downtown Tampa. We could point to the various comparables.
From the window, there's comp 1, 2, 3.
Yeah. And so we were able to get it done, and that worked out well. Our clients were taken care of and made whole. And as a citizen of Tampa that appreciates our history and the what the Tampa Theater means to Tampa, they now own every piece of it.
It's clean, free and clear.
Exactly.
Exactly. Hanging over it. Yeah. That's a great example. And again, very opposite of what I think when I think eminent domain, and just a very eye-opening case study. Another one, and we can kind of talk about some of these others kind of in conjunction probably, but I want to talk about, I think this one that I'm showing here is more access focused. Andrew, this is the one on 95 Oslo Road.
Yes.
Can you give us a little bit of background on that and tell us a little bit about the impact?
Yeah, I mean, our client owned both sides of the interstate on Oslo Road, and it was taken for a new interchange that is being built. I think it's already built in this area. And the big issue here, and I think we talked about it earlier in our conversation, was our client owned that triangle on I guess what would be the east side of the road. On the left side of 95. And it really didn't have access to Oslo Road directly. But that's the parcel that they had a neighborly agreement, for 30, 40 years, that this property had direct access to Oslo Road through an easement agreement that they had. But it was not reduced to writing. And so the DOT was, their value was very low on this property because it had very difficult, had
They look at it and
access
say there's
challenges.
no access, so what's the
No
value?
access, so what's the value? And so we were able to get, and what happened after the taking, there's a second slide which showed you had to go about 3 or 4 miles to get back to this property. And so the DOT's valuation of this site was based upon a property that had, negligible access, when in reality it had access to the main highway through an easement. We got that easement in place before the date of taking. And it's critical for people to understand that there are certain deadlines in the eminent domain process that if you don't meet them, that ship has sailed.
And even from a real estate perspective, if you do have good old boy handshake agreements, please go get them in writing. Even if you're looking to sell your property or do anything on your property.
Yes.
Because you never know what's going to happen with your neighbor's property.
Right.
Maybe they pass away or they sell the property or whatever, and you don't know who you're going to be dealing with next door. So get stuff in writing.
And so this is an example, and I'm so appreciative that we got hired early in the process. And, people always ask, when should you get a lawyer? And my thought, as soon as you know something is going on. And the reason being, it gives you time to get things in writing, get your, for lack of a better term, put your affairs in order before they come take your property. Because literally, if that easement were not reduced to writing, that was probably $500,000, $750,000 swing in the case.
Yeah.
And once we were able to produce it, DOT said, okay, now it's a different story.
Right.
We didn't know it. So, the lesson here is to, that literally, without having a lawyer involved, I think that people have said, well, I did have access, and the DOT and the way the law is, if you don't have it written down, they don't need to consider it. Yeah. And so that was the case that I got resolved a few years ago in Indian River County.
Wonderful. Another one I want you to bring up is ornamental peanut sod farm. I think this was an interesting one. The removal of plants for easement areas, saving the topsoil. Can you
Yes.
kind of give us how all that
Absolutely.
played
My,
into
my
eminent
partner
domain?
Blake Gaylord handled this case, and this was very, very interesting. And I didn't, this ornamental peanut is supposed to be, the next best thing since sliced bread with regards to the way it's durable. It, instead of, using grass for, actually for coverage, like, I think DOT and their medians now use this, and a lot of people are using ornamental peanuts instead of grass because it literally has a just a strong, hardy ground cover that actually blooms, and it's a pretty, beautiful ground cover. There's a yellow flower on it, and you'll see in a lot of places that require substantial ground cover, an ornamental peanut. And so what ended up happening, this was a power line easement taking. And, there was taking for the actual permanent easement and taking for the construction. And so a concern that our clients had is that, you can't just pull this up. I think the root system go down 5 or 6 feet, and it takes a long time to actually
Grab hold
and establish itself. And so, what the power line companies try to do, and the pipeline companies and various utilities, and in the corridor acquisitions, they're always like, well, we're going to save the topsoil, and we put the topsoil back, so you're fine. You're fine. It's not going to be a problem. So okay, well, it wasn't fine.
It's not normal topsoil.
No, it's not. And what's interesting is you can kind of see, I think, if I'm not sure where we are in the with the slides that are being shown, but you could see how it was, literally, with earth movers taken up. They tried to reestablish the topsoil.
The before and after.
Yeah.
Staggered.
And when you look at the after, that whole easement area was it was a mess. You couldn't grow anything worth other than weeds in that area. And so what we were able to do was get compensation, and we were able to resolve this, proving what our theory of the case was, that our ability to grow, and that was a crop, was lost in that 200-foot swath. So
again, it's not just the piece of land that's impacted from an aerial perspective. It can be topsoil, it can be stuff under the ground, it can be stuff on paper from
absolutely. And
entitlements
again,
or impact.
In order to make our client whole, we had to look at what would this impact be on his functional use of the property. And so, obviously the permanent easement and the temporary easement ended up being somewhat of a permanent impact because, there's, in our lifetime, they're not going to be able to grow anything on this.
So the next one I'd like to talk about is a residential mixed use project that you and I were talking about before this. But
yeah,
the impact of setbacks, the impact of access roads on unit counts, on function of a property. Can you kind of give us a little bit of background on this one?
Yeah, this was a case that we handled here in Polk County, and it was a beautiful piece of property. It was, citrus still, land use and zoning was ag, but you could see from the aerial, everything around it is going residential. I think 6 units per acre, something to that effect. It was about a 60-acre piece of property on Lake Smart. And there was a power line easement that was coming in from the west and then coming along the property line to the south and coming across the frontage where there's a local road. So the question always is, what impact does this taking have on the property? Mm-hmm. And so as we started looking at that, we knew that from a land use perspective, there needs to be a change in land use and zoning, because under Florida law, you're able to look at highest and best use of a property within the reasonable foreseeable future. With everything that's going on around here, rezoning.
Which I think that's an important part of the equation here, because it's not just what your property is at the moment, but it's what could it reasonably become, or what is happening around it. You can take that into account when you're determining something.
Now, what's funny, the law is like, it can't be speculative, and so you need to be able to show examples of where rezonings, because everything needs to go back to the market.
So you don't have to get it done. You don't have to get a rezoning done before you're, like, if you found a piece of property, found this property, for example, residential development all around you, you know that's what's going to happen. You
Right.
can point to 20 examples.
Correct.
I, as a landowner, don't have to go rush and get a land use change done before the eminent domain
No, you do
case
not.
is heard or proceedings occur.
That's exactly right. Under the law, you're entitled to presume, the highest and best use within a reasonable foreseeable future. And that typically that's a 3 to 5 year period. A concern that we always have is if you start to go do your rezoning and it's denied,
And they say no. Yeah.
and then your ability to make
Which
that
can
argument,
happen for
it
various
can.
reasons, even if you think it's a total layup. Sometimes you don't ever know how that's going to go.
Yes, and so, if we've got examples in the marketplace and things happening around and increased population, demand, things of that nature, the law allows you to consider that. And so, in this particular case, both sides, the power company as well as our side were, thought the highest and best use was future
So this
residential.
is a power line.
This is a power line
taking.
case. Exactly, yes.
And you can see that in this purple.
Yeah, the purple, that was
purple
the
on the
easement.
screen.
It was
That's
about-
the easement, the power line easement.
It was about 100 foot in width. And so the question that I had as a lawyer is, okay, if you had to go through the process of rezoning, getting the land use change, rezoning it, what requirements, or is there an impact to the requirements? Can you meet the requirements is a better way to say it. Can you meet the requirements in the after condition? Well, in doing our research, we learned that the county has a requirement that your main access road or that you front on has to be, I believe it was 60 feet in width.
Yep. That sounds right from a road
Or you
size
would know better.
perspective. Yeah,
60
60 feet. That's the number I've always been told.
Okay.
Yeah.
But so we were talked earlier about dedications. So in order to do that, the road was about, I think, 30 feet. We would have had to dedicate 30 feet to the local government to meet that 60-foot requirement. But the county's requirement is that land has to be free and clear. If the easement that was proposed by the power company was on that property boundary as they proposed, there is no way we could have complied with that 60-foot.
You'd have to go in, or you either couldn't, you can't put the road right under a power line.
No, you can't.
Correct.
You
It's
can't.
the
They
issue,
wanna-
right? So in this case, you'd have to keep encroaching if you want, or reroute it even somewhere else.
Well, so the power line was actually, we got the power company to shift their easement 30 feet in order for us to be able to, in the future, dedicate that 30 feet to get a 60-foot right of way.
Gotcha. Makes sense.
Without doing that, we could not get our rezoning. So this property that had a value of probably $2.5 to $3.5 million, and that was assuming maybe about 200 units, is what 200 plus units. Without having that shift and without complying with that zoning reg, you could only put 2 to 3 units on this entire 56
Yeah,
acres.
you'd be subject to the ag density.
Yeah, you could not meet.
1 per 5, 1 per 10, whatever.
I think for whatever reason, 3 units stick out. So, so what we were able to do in this is, by doing that, our due diligence and going through the details.
And probably starting early to have time to talk to the various parties impacting this site.
Absolutely. We were in communication. We had a land planner. We were in contact with, and an engineer. We were in contact because we had to look at, not only, so, if you comply and get the rezoning, what impact does that power line have on your development? Well, most people would rather not be next to a power line. You're going to have several of your units encumbered
Yep.
with a public transmission line. So, it wasn't just the rezoning issue. You ended up having residual impacts. I mean, you can't, something this large, you can't buffer it. It's going to be there. And typically people will pay less for a piece of property with this kind of I guess, improvement or infrastructure on it versus one that doesn't.
Right.
Most people, would you rather live next to a power line or next to a property without a power line? Most people would rather
Probably choose not.
choose not.
If you had the
And so we were able to, get in early, go through, it's funny because, once you do something long enough, you start, seeing patterns. And, we had this on another issue where, a power line was going to be there. It's a corner piece of property. What were the setbacks for corner, and what needed to make sure that it was pulled out of that.
You've learned the good questions to ask
Yeah,
as you've done this, and you see a lot of the same questions pop up.
Yeah, I don't know the answers, and that's another thing. I keep asking myself, why should you have a lawyer? Well, you should have a lawyer because the lawyer knows what questions to ask.
That's right.
And experience has been a great teacher. And so, but this was a very, very interesting case because it brought up issues that typically you don't see. And with this taking, it looks pretty much, well, it's X amount of feet, X amount of width. What's the property value? Well, problem is there's a zoning requirement that we cannot meet where they proposed it. Mm-hmm. And they were very cooperative, and we got it moved and compensated the property owners fairly. And so it was interesting case.
Like all of them are. We've talked a lot about development, land, transitional land, major roads, commercial properties, historic properties. Can you talk a little bit? There's an example in here about a recreational land, a 75-foot power line easement that was having a negative impact on some things on a piece of recreational land. So yes. I don't know if you could kind of talk a little bit about this case and the impact there. Again, for we do a lot of development land, a lot of commercial, but we do a lot of hunting and ranch and rec type properties. So that impact could hit some of our clients as well.
Yeah. Well, this is a beautiful piece of property in the panhandle of the state, and the elevation changes through here. It's spectacular. And you could see if you're able to look at the pictures. I mean, the home it is truly a gorgeous.
I need a property like that.
How about it? How about it? And so what happened? This is a power line easement that's going next to a power line easement. It's kind of funny because most hunters tell me one power line's okay. And there's an existing power line because allows you a place to put your deer stand.
Mm-hmm. And that's right.
But you don't need two. And so this was a 75-foot power line, and the problem is it was destroying the best turkey habitat on the property. And so the question that we had to try to figure out is how do we solve this problem? And you can't. There's certain things you can do, and what we were able to do is and this was a lot of fun because the attorney for the power company, the decision maker for the taking authority, he was a hunter. He understood.
He got it. Yeah.
He understood all the problem, and we literally met on the property, and we're riding on the four-wheelers, or just going and take a look at it, seeing the impact, and so what we did as part of our claim to make this owner whole. We got an estimate from a forestry company to try to reestablish to the extent they could the quality of that area.
The cost associated.
The cost associated
with recreating that or
yes.
taking how you make it that high quality piece of property.
Yes, and it doesn't happen overnight, and there'd have to be some management to it. And so we got an estimate from a forestry expert, environmental group that's based out of the Panhandle that does this stuff, and so they gave us an estimate, and we came up with some ground cover that we requested that they place on the new easement area, and so everything was going great except for when they finished construction, and this is another reason why I think it's important to have a lawyer. This was a case that a lot of these cases we resolve through the court system. That doesn't mean, we submit an agreement, and so, this one, we submitted the papers to the court entered a judgment, and as part of the agreement, it had everything laid out that both parties were supposed to do. What happened on this case was that I got a call back, he didn't want this work happening during hunting season, which I totally understand. And so once it happened, when you dig you're locating these big, huge power poles, the slurry that comes out,
I'll bet
it's substantial. And so it's a mixture of water and sand and everything. And it came out like concrete. And then they mulched a lot of the trees, and then they put their ground cover seeds on top of that. Well, it never took. And so I get a call from my client, said, Andrew, there's a mess here. What can we do? And so I contacted the lawyers for the other side, and because as part of our agreement, it was a court order, and we always put in there that the parties reserve the right to enforce the agreement. And our position was that they didn't do it in a workmanlike manner that should have been done. By putting it on top of the slurry, on top of the mulch.
So after the proceedings were completed, this all happened after the fact.
Yes.
The impact afterwards, they were able to go back and kind of raise their hand and say, hey, this was...
We were able to go back and just, money heals a lot of wounds.
Mm-hmm.
And so, my client got an estimate on what would it cost, went back to the forestry to basically clean this up and reestablish some ground cover. And, it worked out great for everybody, where, my client got additional funds, as they should have, for that. But that was a situation where, had we not gone through the court system, enforcing that agreement would have been very, very difficult. But since we had that agreement in place with the court, we didn't have to file anything, with some phone calls, and I have a lot of respect for the lawyers we were dealing with, and in the
Everybody was
company.
pretty reasonable.
Everybody was wanted to do the right thing,
Right.
but without those documents and our ability to come back, it would have been much more difficult. And so, but that was it's a beautiful piece of property, and it's one of the fun things that I love about my job is I'm not stuck behind a desk. I get to go on properties like this throughout the state of Florida.
Understood. Let's talk a little bit more about a couple more that I thought were interesting real quick. We're kind of running up on time, but there was one that I wanted you to bring up, the Trinity Church of Wesley Chapel.
Yes.
I believe there were some impacts from a parking gathering perspective as it pertained to church events, fellowship events, things like that. And what was the theory behind what was going on, and then how you were able to make them whole?
Okay. We've talked about, the functional utility of a property. And so this is a church on State Road 54. And you can see the beautiful oak trees it has in the front. Unfortunately, most of those oak trees are already within pre-existing right-of-way.
Gotcha.
And so what that means is the government can use that property and take those trees down without having to pay compensation. So, if you were just looking at a map, there was still a setback, there was still an area, but what was happening there, and it was important for us to understand the mission of this church, which is to preach the gospel. And they do it by, getting their message out. And so they strategically have a lot of their events on the road so people can see what's going on there.
People that drive by, it's a heavily trafficked road. They can see what's going on.
And they have their Easter egg hunt. They have a lot of their, when they have carnivals, they've got these big slides that go down there. And for, Easter, Christmas, and the big holy days and big church events, that front area is jam-packed with parking. And so what we looked at, the Department of Transportation came in and looked at it as a strip of land and we'll pay you X amount. We looked at it as from a functional utility standpoint. They are using, that is every bit as important to this church and their mission as the building. That's exactly right. And so what we did was, we talked about, in the valuation standpoint, the functional obsolescence to the property, which is a damage, because again, a church is a special purpose property. Typically, you don't find churches that are successful and thriving on the market.
Right.
And so what we were able to do was, I don't know if you see a picture, they use it for Easter egg hunts. It's just a great area, and that we needed to make sure that they were paid for this loss. And so, going back to the special purpose property, understanding how this church uses that area and the importance to it. And you learn this by sitting down and talking with your clients. And I know that you do that as well all the time. I mean, you need to understand how your clients use their property, or how they intend to
understand
use
what
it.
their goals and objectives are
Exactly.
too, because those aren't always the same in every situation.
Yes.
Well, that's really interesting. And I think my goal and hope for this session today and podcast today was that we could talk about a lot of different types of properties. And I think we have.
Sure.
We've talked about coffee facilities that were very customized in urban environments. We've talked about raw land and high growth markets impacted by roads or utility setbacks and easements, and as well as churches and recreational land. So I appreciate you coming on today. I appreciate your involvement at our firm, and our events that we do, and you're wonderful at presenting all this. And so I know our audience has really enjoyed it as well. And I really appreciate having you on today. And you have any parting thoughts?
If you are faced with a taking, contact a lawyer. I'd hope it to be me or my partners at Gaylord Merlin, but you really need to have an attorney take you through this process. And, fortunately, we live in a state where the recovery of attorneys' fees and costs are constitutionally protected.
Doesn't cost them a thing.
Doesn't cost them a thing. And it's just, you don't know what you don't know. And we've been doing this a long time. And just, I think that oftentimes people, like I said earlier, are hesitant to get lawyers involved. But this is a situation that I think you're helping yourself if you do.
Absolutely. Could not agree more. Well, thanks again for coming on. And,
thank you for having me.
Look forward to next time.
Absolutely.
Thank you for listening to In Our Expert Opinion Real Estate Podcast. Don't forget to subscribe on your favorite podcast app so you never miss any of our upcoming episodes. For more on land and commercial real estate, please connect with us at saundersrealestate.com.